Presentation for You, Part 1. Welcome to Afternoon Tea with Karen. The truth about treaty. The 13th of January 2025 from the National Indigenous Times. The focus will include the principles and objectives for the statewide treaty, the legal recognition and effect of a treaty, and the creation of an ongoing First Peoples representative body. It would look at the governance and oversight of a representative body and the interaction between said representative body and the Victorian Parliament and government. Other topics to be discussed include implementing the accountability mechanism under the National Agreement on Closing the Gap and working to support ongoing truth-telling, education, healing and reconciliation in Victoria. The government are represented by senior Department of Premier and Cabinet executives, whilst appointed member negotiators represent the Assembly. The negotiations are overseen by independent treaty authority based on the rules set out in the treaty negotiation framework. From Jacinta Allen on the 13th of January 2025. Evolving the First Peoples Assembly into an ongoing representative body. Interaction between a representative body and the Victorian Parliament and government. Processes for negotiating future iterations of a statewide treaty. And the handy greens. The United Nations Declaration of the Rights of Indigenous People. UNDRIP is the key document on which we base our National First Nations policy. To achieve these fundamental and international rights, we will ensure that Australia's obligations under the UNDRIP are written into domestic policy. 3 core priorities in this order. 1. Truth. Establish a Truth and Justice Commission. That one's already happened in Victoria. It was set up in 2022. It will establish an official record of the impact of colonisation on First Peoples in Victoria. See URUC's letter patent that sets out its mandate in detail. So in 2023, it released URUC for Justice report and now looking into land, sky and waters, health, housing and education. So on the timeline, this is when the bail laws change. Anyway, back to the Greens. Number 2, treaty. Enact a national treaty and or treaties with First Nations people in this country, sovereign to sovereign. 3, voice. Subject to treaty negotiations, establish a national First Nations voice to be included in the governance of Australia as determined by First Nations people. Now, measures here. Number 9. Review the native title legislation to make it consistent with the UN Declaration on the Rights of Indigenous People. That's one of the things the yes vote people were voting for. So from November last year, WA's that's too hard to say. WNs take Roy Hill Native Title battle to United Nations. I struggle with most words that are more than 3 syllables. So 200 people that had spent more than a decade fighting for native title recognition over an area north of Perth known as Roy Hill. The federal government rejected a ruling by the United Nations Human Rights Commission that it violated international rights when it dismissed a native title claim by the group. The court found that Ms. Coffin and her cultural group were not Nyapali, saying they had provided no evidence to suggest they were part of the wider Western Desert Society. Ms. Coffin took her battle to the United Nations Human Rights Commission, alleging the group had not been given fair treatment in the courts and could not effectively take part in the proceedings. In 2023, in March, the committee ruled that Australia had violated 4 key articles of the International Covenant on Civil and Political Rights, and the federal court should reconsider the Wana Nyapali claim. It was rejected by the Attorney General Mark Dreyfus. Ms. Coffin's legal representative at the UN, Scott Callanan, said the group was not able to effectively take part. They were not put in a position where they could, in an informed manner, participate in the proceedings or feel like they've been consulted with, he said. Mr. Callan said the government's response was completely unacceptable. The committee comprehensively found in favour of my clients, and Australia has essentially just ignored that, he said. Without legal recognition, there is no official avenue for the Wana Nyapali to engage with the government or mining companies, and therefore cannot be part of decision making when it comes to the land's massive mining tenements or receive any mining royalties. In 2018, the court granted the Nyapali determination. The Kala Nyapali Aboriginal Corporation, which manages their native title determination, didn't respond to the ABC for requests. Let's have a look at them. So firstly, warning to Aboriginal and Torres Strait Islanders, this website may contain names or images of people who have passed away, including those who may have recently passed. Looks nice. Occupation of the Nyapali land by our people can be verified to at least 41,000 years, being the second oldest on record in Australia. It's here and looks like a nice, fun place to live. Or even just go on holidays too. Fire ecology. Director of Economic Consulting Services Murray Meaton has assisted in native title cases nationwide over the past 2 decades. The only way I think it can be resolved is for the government to have its own anthropology and its own expertise so that it is in a position to resolve those disputes. The federal government recently invested in improving the native title claim system, including a $20 million investment in the 2024 to 25 budget to expedite claim resolution and help resolve post-determination disputes. She got done for trespass. I want to look after our people, and we intend to build our own community on Roy Hill at the Fortitude March to begin our journey to self-determination. That's from the UN stuff. Trust me, I've done thing on it already. Her lawyer, Scott Callanan, had also penned a letter to the UN following the government's response, asking the committee to take further action. This is from the Australian Human Rights Commission, the UN Declaration of the Rights of Indigenous People. Pause and read. Further recognising the urgent need to respect and promote the rights of Indigenous peoples affirmed in treaties, agreements and other constructive arrangements with states. Emphasising that the United Nations has important and continuing role to play in promoting and protecting the rights of Indigenous people. Article 3, Indigenous people have the right to self-determination, the lady from the article. 11, this includes the right to maintain, protect and develop the past, present and future manifestations of their culture, such as ceremonies. 18, Indigenous peoples have the right to participate in decision-making matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions. So the treaty and truth and stuff. Article 20, Indigenous peoples have the right to maintain and develop their political, economic and social systems or institutions. Indigenous peoples have the right to the lands, territories and resources which they have traditionally owned, occupied or otherwise used or acquired. Indigenous peoples have the right to own, use, develop and control lands, territories and resources that they possess by reason of traditional ownership or other traditional occupation or use, as well as those which they have otherwise acquired. States shall give legal recognition and protection to these lands, territories and resources. Such recognition shall be conducted with due respect to customs, traditions and land tenure systems of Indigenous peoples concerned. Tenure. States shall provide effective mechanisms for just and fair redress. That's happened with the payments to the stolen generation. Nothing in this declaration may be interpreted as to diminish or eliminate the rights of Indigenous peoples contained in treaties, agreements, and constructive arrangements. But they are after native title. That's in the High Court, thanks to Eddie Marbo. 39, there was a thing a while ago about housing loans. And in Victoria, proof of Aboriginality. Your Aboriginal or Torres Strait Islander heritage is something that is personal to you. You do not need a letter of confirmation to identify as an Indigenous Australian. However, you may need proof if you're applying for something that is specific to Indigenous persons. Government agencies, you need to being of Aboriginal or Torres Strait Islander descent, identifying as an Aboriginal or Torres Strait Islander person, being accepted as such by the community in which you live or formerly lived. All these things must apply. The way you look or how you live are not requirements. And here's a Centrelink form. So yes, you only have to get some people, personal knowledge, organisation records, council records, school records. So not births, deaths and marriages. Not having two Aboriginal parents. Or even one Aboriginal parent.
A few moments later.
Ghazali is correct that the expert mechanism and national human rights institutions can play an important role, so critical for the implementation of the declaration. His brief points, I joined Ghazali in his desire to render more specific and nuanced our discussion about the declaration, which is evidently, in law, much more than non-binding.
And that'll do. Next, part 2. See you later, bye.